evening everyone. Thank you for joining me again for Facebook Live Legal Surgery. Tonight will be based on lasting powers of attorney and different types of power of attorney that you can have. So the way the Facebook Live Legal Surgery works is that you can ask any questions throughout. Please just feel free to interrupt and ask any questions. I've decided tonight to have a bit of a moving screen on the background to give a bit of extra feel to it, but it may be a bit bright in places, so apologies for that. If you hear the rain as well, apologies for that. It's typical spring weather. But as I say, tonight's Facebook Live Legal Surgery will be about how to deal with lasting powers of attorney and the benefits that they may have. So if you do have any questions, please ask. The previous surgery was about appointing guardians and parental responsibility. I've done the blog on that, and that will be going live in the next 24 hours, so any information on that you'll be able to see. So with regards to lasting powers of attorney, I've got my website, which is www.eco-wills.co.uk. Hi everyone who's saying hi, it's kind of you. If you want any information, don't worry about taking notes tonight. It's all on that website, and you can also contact me at any time, obviously, to ask any questions you might have as well. So a power of attorney is a legal document that gives a person a legal authority to make decisions on your behalf relating to property, finances, medical, that kind of thing. So there's different types of power of attorney, and you may well have heard of these different types. So there's a general power of attorney, and that can be general or specific, and usually it's granted for decisions to be made regarding financial affairs whilst you're unavailable to make decisions yourself. So this might be when you're on holiday, or if you're going on if you're going into hospital. It's for usually a temporary timescale rather than more of a permanent thing. The historical power of attorney was called an enduring power of attorney. Now, if any of your relatives have those, they do still are in existence. They were in place prior to the 1st of October 2007, and they were used instead of what we now use as lasting powers of attorney. So the enduring power of attorney was one document, and it covered everything. So it covered your finances, your medical, health, welfare, that kind of thing. Now, that document didn't have to be registered at the Office of Public Guardian, so it still exists, and it only was registered when an individual lost mental capacity. Now there is a slightly different way of dealing with things to safeguard against any sort of potential issues. But if you, as I say, if you do have one of those in existence, it's not a problem. They are still legal, and they can still apply for any family members. They will just need to be registered when they lose capacity. Now, the current position is the lasting powers of attorney. Now, a lasting power of attorney is a way of giving someone the ability, who you know and trust, the ability to deal with your affairs if you're unable to do so. So, just as a reminder, an attorney is much different to an executor. An executor only comes into play after you've died, and an attorney comes into play during your lifetime. If you have a lasting power of attorney, it will cease on your death, and then your executors will take over the administration of your estate. So there is a big difference, and there can be a bit of confusion for people, but that is the main difference there. So the lasting powers of attorney we have at the moment, there's two different types. There's health and welfare and property and finance. So they are exactly as they say. The property and finance is anything to do with any bank accounts, houses, anything to do with money. That is under one power of attorney. And then you have health and welfare, which could be in relation to any residents, medical treatment, nutritional requirements, social activities, family contact, things like that. So it's not necessary for you to have the same person appointed under each separate document. So you may have someone in your family who would be way more suitable to deal with your finances, but perhaps aren't as personal as other members. And then you might want someone to deal with your health and welfare who is slightly different and may have a better idea of how you would like to be sort of treated and what your ideals are moving forward. So, as I say, they do not need to be the same person. You can also appoint substitutes. So if the first attorneys can't act, then you can have substitutes who come into play after that. So in terms of choosing an attorney, they need to be anyone who's aged over 18. You can choose anyone you trust to deal with your matters, although generally people choose a spouse or a member of the family who they trust. You are free to appoint whoever you want, be it a friend or a professional or anyone else. But generally speaking, it would be someone who you are able to discuss your ongoing plans with. It makes it a lot easier it's kind of a moving goalpost. This will go on for the rest of your life, unless you revoke it, which is very unlikely. So it's important that you actually discuss with the person who you are thinking of appointing as your attorney to make sure that they are happy to take on that role. They will need to sign the documentation to confirm they're happy as well. So it's important to make sure that you discuss your thoughts moving forward, if they are prepared to take on that responsibility for you, and whether or not there's an ability to have the powers of attorney in place, especially for property and finance, whilst you still have capacity. So it may be that you just need assistance on an everyday basis, or you might be going away, and it's just an ongoing additional thing. If you've got an attorney in place, they can look after your affairs. If you're unable to, they cannot. So when we talk about losing capacity, we don't necessarily mean dementia or Alzheimer's or any illnesses related to that. We could mean temporary incapacity. If you to be in a car crash or have a major accident, you're unable to deal with your affairs. If you don't have an attorney appointed, it is difficult for someone to deal with those things for you. So if you do have a lasting power of attorney in place, it means that someone can step up, deal with your finances. You might be renting a property, paying a mortgage, that kind of thing. Without the authority, these people really struggle to deal with your affairs. Now, on the subject of Alzheimer's, that kind of thing, if someone does lose capacity and they haven't got a power of attorney, then you have to do something what's called a deputyship order. Now that is a lot more of a long-winded process. It has to be a court process. It's a lot more expensive, and it will take about 5 months to complete. At that time as well, you won't have the benefit of choosing your attorney. They will be appointed by the Court of Protection. So that's another reason to have something in place at this stage. So it's a long topic. I could talk to you for hours about it, but realistically, if you've got any questions, please do let me know. Please contact me at any point. In terms of costs, my fees are all on my website, and this is not a plug necessarily to sell that, but you will need to pay your legal advisor's costs plus an £82 registration fee per document. So there are some exemptions as well. There's a long list, and I will upload who might be able to be exempt from these fees, and I'll upload that for you for ease of reference. There is also a very good information booklet on the Age Concern website, and that will indicate, that will give you all the information you need. But as I say, please do ask. I've got a question here which says, how many attorneys can I have? You can have up to 4 attorneys and more substitutes, or as many as you like, really. It's more beneficial to have 2 or something along those lines with substitutes. There's different ways in which you can have appoint attorneys. So you can be joint and several, or jointly or completely several. So joint and several means that they can either act together or independently. If you have a power of attorney and you've got a number of attorneys appointed, it can be a power struggle between those attorneys and who's making the decisions and who's doing what to keep control of. It's more beneficial to have 2, maybe 3 people appointed, so there's less of an argument moving forward. They can deal with your affairs easily, confidently, without any sort of major issues cropping up and disputes between them. And then you can have others as substitutes as well. So if the first can't or are unable to act, you do have the substitutes there as well. There's another question, do you have to have the same attorneys for all matters? No, you don't. So you can have separate attorneys appointed for health and welfare and others for property and finance. So it really is completely up to you who you appoint and who would be best suited for each role. But as I say, it is important to discuss that with them. I think that's all the questions that we've got and we've had now. I've answered those, but if you do have anything else in the meantime, then please do let me know. Thanks again all for watching. Any questions, message me. I will put the blog up over the next 2 weeks. Please do follow me across all social media. It's Twitter, Facebook, Instagram, LinkedIn and YouTube. And as always, it's Lucy Beck, the lawyer who listens. Thanks very much.